Hi, thanks for joining the webinar. This is Amy Eisenor. I'm one of the attorneys here at Standpoint. Standpoint is a nonprofit program, and we provide over-the-phone legal advice to victims of domestic and sexual violence, advocates that work with them, attorneys who represent them, and anyone else who has questions about advocacy or legal rights of victims of domestic or sexual violence. We're really glad you're here with us. I hope that this training will be beneficial to you. Ty is going to be administrating and managing the webinar today. And if you have questions, she will be routing those. So I'm going to hand it over to her to talk about some logistics, and then we'll get started.
Good afternoon and welcome to the webinar. Again, my name is Ty Sinavan. I'm the Advocate Support Program Manager here at Standpoint. So my role today is going to help facilitate the questions portion of the webinar for Amy. So if you have any questions, please type your question under the questions tab in the control panel. Amy will be checking in with me periodically throughout her presentation to answer any questions that you have. And before I let Amy start her presentation, there are a few poll questions for all of you to answer. And these questions help Amy to know the audience and who she's presenting to. So I will start with the polls now. I will give you probably 5-10 seconds to answer each question, and then I will reveal the results after. So the first poll question is, how many years of experience do you have as an advocate? Okay, I'm going to go ahead and close that webinar. That poll, not the webinar, sorry. And I'm going to share the response. And so it seems that 11% of the participants today have less than a year experience. 26% have between 1 to 3 years, and 42% have 3 to 5, and 11% have 5 to 10 years. And we also have another 11% that have more than 10 years of experience. Okay, so I'm going to go on to the next question. And the next question is, how many sexual assault cases have you helped a client with in the criminal process? And the selection is none so far, 1 to 5 cases, 5 to 10 cases, and more than 10 cases. So I'll keep the poll open until I see that all of you have voted, and then I will close the poll and reveal the results. Okay, I close the poll, and the results are 24% have not helped a client with an SA case, 52% have 1 to 5 cases, 19% 5 to 10 cases, and 5% have assisted clients with more than 10 clients with SA cases. Okay, so the third poll question is, what concerns have you experienced when working with law enforcement? Lack of response, lack of understanding, not sensitive to victims, not willing to work with advocacy, or you have no concerns at all. Okay, I'm going to close the poll now and share the results. And Lack of response is at 22%, lack of understanding 26%, law enforcement not being sensitive to victims another 26%, and not willing to work with advocacy 17%, and 9% of you have no concerns. Okay, so we have another poll question, which is the same as the one before, but this one is, what concerns have you experienced when working with prosecution? And it's lack of response, lack of understanding, not sensitive to victims, not willing to work with advocacy, and no concerns. And so just go ahead and click on the one that you see as the most prominent issue and share that one, because sometimes you might have a couple on there, but we're just looking for the main issue that you experience. Okay, I'll give you a couple more seconds to put your vote in. All right, I'm going to go ahead and close the poll now. And we have 15% of you saying that lack of response is the main issue, 12% saying lack of understanding, 27% says not sensitive to victims, 15% is not willing to work with advocacy, and 31% so far have seen no concerns. And we have one last poll question, and that one is, how many successful prosecutions to conviction and sentencing have you experienced? None, less than 5, 5 to 10, and more than 10. Okay, I'm going to go ahead and close the poll and share the responses. 33% have not had any successful prosecutions to conviction and sentencing yet. 48% has less than 5, and 15% 5 to 10 cases, and 4% of you have more than 10 cases that have been successfully completed. Thank you for your responses. This webinar is being recorded, and I will be uploading it to our YouTube channel in the next week. I'll email the recording out on our listserv as well, so you'll get notification of that. If you aren't already subscribed onto our listserv or to our YouTube channel, please subscribe. Connect with me after the webinar and I can give you details on how to do that. My email is thi, Thi, at standpointmn.org. And if you email me, I will email you back on with instructions on how to subscribe to our listserv and also to our YouTube channel. Also, just putting a plug out there, if there is a topic you would like more training on, please don't hesitate to let me know. Again, you can email me at thi@standpointmn.org, and I'll be happy to jot those down. And we do webinars once a month. Usually it's every third Thursday from 3 to 4:30, but sometimes we do change that depending upon our schedule. So, all right, that's all I have for now. I'm going to go ahead and pass the mic on to Amy to start the webinar.
Okay, thank you, Ty. If there's questions that come up, let me know, and I'm happy to stop during the webinar to answer questions. I want this presentation to be as beneficial to the listeners and the advocates that we work with as possible. So if I'm on a topic that they have questions about, feel free to send those to Ty, and she will interrupt me and we'll talk about that. I always want to give a trigger warning at the beginning of my presentations about sexual assault because it is a difficult issue to talk about. We'll be getting pretty specific into language about body parts and acts that constitute sexual assault. And so please take care of yourself. If you need to mute it or step away from the webinar at any time to make sure that you are emotionally safe, please do so. I also want to give a caveat about using gender pronouns. I will probably most likely during this webinar refer to perpetrators as male and victims as female. And in our work, we know that that's not always the case, that females can perpetrate on males and there is same-sex violence occurring as well. But for the ease of conversation, I just wanted to put it out there that we are aware of that and sensitive to that, but wanted to uh, make it simpler for speech purposes. Working with sexual assault victims is different than working with domestic violence victims. We want to always have that trauma-informed standpoint coming forward, but the way that this criminal law process works is very different. And so we wanted to provide an opportunity for you all to hear about that and ask any questions that you have surrounding that topic. So the beginning of this webinar will be about what does Minnesota statute define as rape or a sexual assault and what is criminal in nature in the state of Minnesota. It's important that advocates know the statutes and are aware of what constitutes the act that is prosecutable. And so we'll go through that. It's a little monotonous, but I'll try to keep it as interesting as I can. And the second half then of the training will be about, well, I guess it's 3 parts. First, the statutes, then reporting how working with law enforcement looks and works, and how as advocates we can best support our clients in doing so if they choose to do so. And then the third part will be about the criminal law process, the court process itself, working with prosecution from the beginning of charging all the way through sentencing. If we don't have time to finish all of the sentencing options, we will look to a second webinar on that topic, but for now we're going to see how far we can get today. So Minnesota law defines criminal sexual conduct in Chapter 609.342 through 609.3451. And there's 5 degrees of criminal sexual conduct that we'll talk about today. They're kind of confusing because they're long and there's a lot of language in them, but it's easy if we think about them in 2 separate sections, penetration or contact. So penetration is defined as the entry of a body part of another into any orifice of the victim. So oral penetration, vaginal penetration, or anal penetration all are included under criminal sexual conduct in the 1st degree and in the 3rd degree. Contact of any personal body part with the body part of the perpetrator is criminal sexual conduct in the 2nd degree or the 4th degree. And we'll talk about what factors go into place to make it 1st and 2nd degree versus 3rd and 4th degree. But if we just think about it as 1 and 3 are penetration, 2 and 4 are contact, and then the description of the act lays out the degree or the significant level of the crime. So 1st and 2nd degree, 1st degree is penetration, 2nd degree is contact. Anytime that the victim is under 13 years old and the actor is more than 3 years older than her. So that occurs when some of these are and some of these are or statutes. So if the victim is under 13 and the actor is more than 3 years older, if the victim is 13 to 16 years old and the actor is more than 4 years older but in a position of authority, and the victim has a reasonable degree of fear of great bodily harm to herself or another person. So if the perpetrator tells a victim that I'm going to hurt you if you don't do this act, or that I'm going to hurt your family or your friend or your child if you don't do this act, that creates a great a fear of great bodily harm to herself or another. If the actor is armed with a dangerous weapon, or the victim reasonably believes that they are. If they have a finger gun in their pocket and they say that they're going to shoot her, and she believes that he's going to harm her, whether he has a weapon or not is not required. The fact that she reasonably believes that he does and is in fear of great bodily harm makes it a first or second degree criminal sexual conduct. If the actor causes personal injury to the victim and either uses force or coercion to accomplish the act, or knows that the victim is impaired or helpless, then it's a first or second degree. So any physical injury to her, that's going to require a actual demonstrable injury, or force or coercion. He tricks her into it or tells her that there's going to be consequences or forces her. So this is the typical act of rape that we think of when we're thinking of force and harm to our clients. Ty, if you could send out a message to ask them to stop, that would be great.
Okay.
Thank you. Sorry about that. We're getting messages and they're coming up on our screen. So if an accomplice to the perpetrator uses force or coercion, or an accomplice has a dangerous weapon, or the victim reasonably believes that they do, then the actor performing the sexual act is liable for that too, and would be guilty of first or second degree criminal sexual conduct. So someone else in the room says, I have a gun, or I'm going to hurt you, or I'm going to kill you, or she thinks that that person has a weapon. If the actor has a significant relationship with the victim and the victim is less than 16 and the actor used force or coercion, the victim suffered personal injury or the abuse involved multiple acts over an extended period of time. So a significant relationship is typically a parent, a teacher, a coach, a pastor, and the victim is under 16 and the person used force or coercion, or the victim suffered personal injury, or the abuse occurred multiple times over an extended period of time. So that's what we typically think of as either incest or child sexual abuse, typically. But that could be a gymnastics coach with a 15-year-old, and the gymnastic coach might only be 19. So it's not always the acts that we think of. So moving on, criminal sexual conduct in the third and fourth degree. Again, third degree is penetration and fourth degree is contact. So if the victim is less than 13 and the actor is less than 3 years older than her, or the victim is 13 to 16 years old and the actor is more than 2 years older than her. However, it's an affirmative defense if the actor reasonably believed the victim is 16 or older. So if the victim tells them that she's 18 and she looks 18 and he has reason to think that, if he can demonstrate in a defense that he reasonably believed she was older, it would be difficult for him to be prosecuted. Again, we go back to the force or coercion. If the victim is impaired or helpless and the perpetrator knows that. If the victim is 16 to 18 years old and the actor is more than 4 years older than her and in a position of authority, that's a third to fourth degree. If there's a significant relationship and the victim is 16 to 18 years old, so we often think about that statutory rape age of being 16. At 16 years old, they're able to give consent. But if they're between 16 and 18 and there's a significant relationship, if force or coercion is used, the victim suffers personal injury, or there are multiple acts over a period of time, that's criminal sexual conduct in the third or fourth degree. So again, the significant relationship is typically defined, as I talked about, under criminal sexual conduct 1 and 2. But if the actor is a psychotherapist, clergy member, correctional officer, treatment facility staff member, medical staff, special transportation provider, a massage therapist, or there's certain other specific jobs that are named, and uses that position in order to accomplish a non-consensual sexual act, that is third to fourth degree. So criminal sexual conduct in the fifth degree can also be charged for things that don't include contact or penetration. This is, again, any non-consensual contact of a person's private body parts. However, it does not include touching over the immediate area of the buttocks. So somebody walks past and smacks somebody's butt, that's not a criminal sexual conduct. That might fall under a different crime, like a disorderly conduct, or they may be able to report it under a different form, but it is not criminal sexual conduct under Minnesota statute. Masturbation or lewd exhibition of a person's genitals in the presence of a minor who's under 16, if they know or have reason to know that the minor's present. It also includes attempting to remove somebody's clothes over their intimate parts or their undergarments. So trying to take somebody's underwear or bra off, essentially. It also includes if somebody forces you to touch their genitals or private parts, they take your hand or another body part and place it on their private parts. That's criminal sexual conduct in the fifth degree. Consent is also specifically defined in Minnesota statute, and it specifically requires words or overt actions by the victim that would indicate freely and current agreement that they want to consent and engage in a particular act with the actor. It does not mean the existence of a prior or current social relationship. So if you know each other, if you're dating, if it's your boyfriend, or if a victim fails to resist, that doesn't mean that they gave consent. It has to be an overt action. I'm saying, yes, I'm doing a behavior or action that gives you reason to believe that I'm engaging and interested in this contact. People who are not able to consent include anyone who's mentally incapacitated. So they're under the influence of alcohol or drugs. They're under the influence of an anesthetic or any other substance given to them without their agreement, and they lack the judgment to give a reasoned consent or contact. To contact or penetration. So they're completely out of it due to some substance in their system. They're physically helpless, they're asleep or unconscious. If they're not able to communicate either consent or non-consent, and the perpetrator knows or should have a reason to know that the person's physically helpless. If they're under the age of 16 and the perpetrator is over a certain number of months older that we talked about in those first two slides on criminal sexual conduct in the first and second and third and fourth degrees. The defense that they believe they had consent is not available to people who are in positions of authority over the victim, if they have a significant relationship to the victim, or if they're employed in those certain specific jobs that were listed earlier. So essentially the purpose is that if there's a power differential, if he has some form of control or power over her, he can't say she consented because that power isn't equal for her to be able to not consent, even if she wanted to say no. And consent must exist at the actual time of the act, and it can be withdrawn at any point. So we could start a consensual sexual engagement, and at some point, if I no longer want to engage in this, I can withdraw consent at any point that you attempt to continue. If the perpetrator were to attempt to continue, it then becomes a crime, and it's non-consensual sexual contact, which is then defined under those statutes we previously talked about. So we hear a lot about the difficulties in prosecuting sexual crimes or rapes, and it's true, they can be very difficult, and there are some specific things that are even harder about this crime than other crimes. There's often a lack of witnesses. People don't often rape people in front of other people. It's that he said, she said scenario. There's a lack of injuries. A person can be raped and not have any visible injuries to any part of their body, including their genitals. Oftentimes, our clients have used drugs or alcohol, and having used drugs or alcohol is not giving consent and is not an excuse for a perpetrator to take advantage of them, but it can inhibit their memory, it can inhibit their ability to report. Sometimes people are so under the influence that they don't have any recollection whatsoever of what occurred. And so that can make it difficult for a prosecution of a criminal case because the prosecutor has to be able to prove all of the elements of those offenses we went through beyond a reasonable doubt to a jury. And so that can be very difficult. Also, juries have false expectations and beliefs about rape in general, and they think that if the victim was using drugs, she probably consented and just regretted it in the morning, and they have preconceived concepts and biases against drug or alcohol use particularly in young women. There's also a belief in a lot of jurors that there are a lot of false reports of criminal sexual conduct and rape, and all of the research I'm aware of has shown that that's not true. The number of false reports of rape are consistent with the number of false reports of any other offense. It's no more likely that I'm going to say that somebody broke into my car than I'm going to say that somebody raped me. But a lot of people still believe that there's a lot of false victims out in the world. Jurors also sometimes really expect our clients to cooperate with prosecutors in a certain way or behave in a certain way that's consistent with other crimes. And due to the trauma and the impact that a rape can have upon our clients, they might behave in ways that seem typical or what would be expected by a non-expert in trauma. So they assume that the victim screamed and fought, that they forcefully resisted the perpetrator, that as soon as they got away, they ran away as fast as they could and reported immediately to the first officer they found, that they remain vigilant, that they're always afraid and hiding in their homes and don't want to go out ever again, or that the victim will avoid their assailant, that anytime they see that person, they're going to be frightened. When in reality, oftentimes people who've been traumatized or victimized want to take power back over their own body, and they might consent to sexual activity with the perpetrator after the assault to say, okay, if I'm going to have sex, I'm going to have sex on my terms. If he's going to rape me anyway, I'm going to take back control of the situation. And that's a very common response that a lot of young women have, and that's not understood or accepted by jurors because they assume, why would you ever go back and be anywhere near that person. So we have several options that are available to our clients. And reporting to law enforcement, or reporting to a hospital, or reporting to a school, or reporting to other people is an option. But we always want our clients to know what all their options are, and to discuss with them the pros and cons of that. Why might this be a really good idea and benefit them, or why might it have unexpected consequences that they weren't prepared for. And so if we know all of that and we're able to talk them through that, having that autonomy to make the best decision for themselves is always really important for our clients. So even if they choose not to report to law enforcement, there's a lot of options that are still available to them. They might choose to get a forensic exam. A SANE nurse or a SARS nurse at a hospital can do the forensic exam, and they can do it anonymously and not report to law enforcement. Having a medical exam does not take the power away from the victim to be able to decide what they want to do with it at that point. Or they might want to just get general medical care. They might want to be tested for STDs, or just make sure that their injuries are cared for and that they're safe. But they don't want to have a formal SARS or SANE exam, and they don't want to report. They can speak to confidential resources like you guys. They can talk to advocates and still do safety planning. Talk about how they can protect themselves and make sure that all the typical safety planning we would do in any traumatic incident, or in any incident where a person doesn't feel safe moving forward. There's civil remedies, obviously, of an order for protection if they're in a relationship with the perpetrator, or a harassment restraining order if they're not. And there's tort options that they can talk to civil attorneys about if they wanted to pursue a civil claim against their perpetrator. There also might be other ways that we can provide resources to them besides having them report to law enforcement, including addressing any housing concerns they have if the perpetrator lives near them and they don't feel safe in their apartment anymore, doing lease work, or helping them obtain safe housing if that's necessary in a shelter or other location. Being the victim of such a traumatic event of a rape or a sexual assault can impact their education or their employment. They might need time away from work to care for themselves, or to have medical treatment, or to be with family. They might need educational accommodations, and there's lots of ways that advocates can help outside of the criminal justice system to help victims in all of these areas. Of course, making sure that they're getting counseling or in a sexual violence support group so that they have other people they can talk to and work through the trauma that they've experienced. Another option is to meet with an investigator or detective to ask them about what the criminal process looks like and what they could expect from a detective or officer if they did choose to report. A lot of law enforcement agencies are willing to do that, to have a kind of off the record or more educational meeting with a victim before they determine whether or not they want to report. This often does result in formal reports. After they've spoken with the detective, they decide they want to go ahead and tell them what happened to them. But it's an option if they're not sure what they want to do. And it's really, really important that we're honest with our clients and direct regarding the process, what it's going to look like, how it can benefit them, and what negative aspects might come, because choosing not to report is something that we need to respect. So it's really important as advocacy to know what the process looks like and to discuss the pros and cons of a law enforcement report. At some point, the victim will lose control and autonomy, and they feel like they're losing control and they don't like it, that the police or prosecutors are making decisions that impact them and they don't have any power over that. So talking through that with them is really important, and we'll get to that a little later in this webinar. So if they do choose to report, it's really important, especially in smaller communities, it's easier to do this, but in any community, it's important that advocacy and law enforcement and prosecutors have a really good working relationship, know each other well, have developed respect for each other, and know each other's roles so that we're able to best serve clients when they do choose to report. It might give you an opportunity to give the officer a heads up of what's going on, or to talk with your client that I know this officer, this is how it's going to be, this is how she talks, this is how he interacts, so that they have more comfort in moving forward with that. So if a victim does choose to report to law enforcement, there's going to be an initial reporting period. And this is different in every jurisdiction and every county. So I'm just talking generally about what to expect in Minnesota, but some of you may have had different experiences than this. The initial report is usually taken by a uniformed officer within a patrol division. Sometimes they're called road cops. So this is the first time that law enforcement is learning of this incident. It might be a 911 call. It may be them calling from your office together a week or month or year after the assault. So the officer takes the general first report. They ask the basic information. What type of crime was committed? They ask some specifics about the event, who was involved, where did it take place, when did it happen, is there any evidence available still that can be retrieved, such as, do we want to do a SANE or SARS exam? Do you want to go to the hospital now? If it's a specific location, are there photos available? Does the crime scene still look like what it looked like at the time? Or if it was a year later and the person's moved out of the apartment, it may no longer be reasonable to go to the crime scene. Does the victim need immediate medical assistance? Do I need to offer you an ambulance or medical safety EMS care? Does the victim know who the suspect is or where the suspect is? And were there any witnesses or anyone else that the victim disclosed to? So the witnesses don't have to be a specific witness to the incident. They might have seen the victim come out of a room crying or screaming, or have seen her passed out or super drunk and go into a room with a guy. Did the victim disclose it to somebody right away after they came out of her room? This is what just happened. All those names and information are important to begin the process of writing the report. And when the first initial complaint is taken, the officer generates what's called an initial complaint report number. It's often referred to as an ICR. And that number is really important to keep for tracking purposes, because if you're looking for a police report later, to have that number is what that number is going to be included on every page of every police report following the initial reporting. And so if you have that number, you can track it and ask law enforcement for it and for updates as you move along. So we know in working with victims that being a victim is very traumatizing. They might need time to sort it out. They might be coming to you a year or later after the incident occurred, or you might be meeting them in the hospital immediately after the incident occurred. Our clients blame themselves for what happened. They try to look back through the evening and what happened that I could have done differently to have prevented this, or what did I do that made him think that this was okay? Or They might think other people will blame her. They might think law enforcement will think she's responsible, or no one will think that she's telling the truth. Or she might think that she did or said something that will make him not be forced to take responsibility, make him not be charged criminally, or could compromise the case. So talking that through with them and reassuring them that you believe them and you'll help them through this process, of course, is super important. This is different than domestic violence because it's not always that 911 call that somebody's got injuries, there's a fight, somebody heard something right now. Law enforcement comes to the scene, arrests one of the parties, takes them away. Within 72 hours, there's a bail hearing, and there's a Danko, and we go on our merry way. We get our OFP, start divorce proceedings, or whatever that looks like for each individual client. But in sexual assault cases, that can look a lot different, and the timing of all of this can be a lot different too. And so we'll go through that as this webinar progresses. So full disclosure is absolutely crucial. Anything that a victim doesn't say or covers up or says differently than what really occurred can destroy the whole case. We already have enough issues with trauma and the way that the brain works, and juries not understanding that victims don't necessarily report in a linear manner, and that they might forget things or remember things later and then add them, that they're not changing the story, that that's how their brain is working to protect them. But because that's such a strong issue already, we want to make sure that she's not saying something trying to protect herself that when they find out later wasn't accurate will make the case not prosecutable. So if she was drinking underage, or if she was using drugs, or if she has had sex with him in the past, or if she has been prostituted or was being prostituted that night and it began as a consensual thing and resulted in a sexual assault, she might have a lot of feelings about that and not want to tell the truth. But it's super important that we assist them through these concerns and make sure that they are aware that if they don't share these things, it will destroy the case. So after the initial statement is taken, a formal statement is made, and this is usually done by detectives or investigators. So a patrol officer might take that initial case and then hand it off to somebody else in their office who's going to do more formal investigation and more formal interviews. They ensure that the elements that the facts that the victim provides meet the elements of the crimes that we talked about at the beginning, that what occurred fits into the Minnesota statutory definition of a criminal sexual assault. It's often common that the statement made by the victim at this point will be recorded or transcribed, and this is usually a couple of days after the initial report has been made. If it's made on a Friday night, the detectives come in Monday morning, get the cases that need to be assigned to them, prioritize them, and then determine what next steps they're going to take. It's important to talk over the goals of the interview before the interview so that the victim is prepared. Sometimes law enforcement or detectives will do that. They'll talk with you off the record and say, this is what I'm going to ask you. This is what this is going to be used for. It's going to be recorded. Are you ready? Okay, now we're going to start, so that the victim feels comfortable with that person and is ready to proceed with the more formal statement. The role of advocate during this is to be present if the victim wants you there and to be a support person, but you're not an interviewer and shouldn't say anything during this interview. If the detective and you have a good relationship and are able to do so in a supportive manner and the detective's kind of okay with it, you might want to say, remember we talked about this, did you want to mention that to him? But as far as asking her questions or talking for her, that's not our role in that situation. We want to make sure that she feels safe and comfortable and has you there as support, but that's not our opportunity to talk. As the investigation progresses, the investigator will identify who they need to talk to. Those people don't, again, need to have been present for the assault or seen what actually happened, because these are most often one-on-one events that occur with no witnesses present. But they might be witnesses, again, to the victim's behavior. They might be able to corroborate things the victim said by saying other things that are consistent, that show this is where it really was, this is how she came out, I saw her drinking this much. She came out and her clothes were disheveled, her shirt was on backwards, whatever. Again, we talked about this a little bit earlier. The investigator might go to a crime scene and take photographs. And they will evaluate how best they want to handle the suspect. Do they want to arrest him immediately? That's going to be case dependent, and that's going to depend on when the assault occurred and whether they believe that the person poses a threat to the public at that point or not. It also can affect their investigation, which is why they might make a choice not to arrest initially. If they arrest, it puts time constraints on the investigation and on the charging. If the person's arrested, they have to have a full report to the prosecutor, and the prosecutor has to be able to write a formal complaint within a certain number of hours of the arrest of the person being held. Also, they might choose to arrest if the person's a flight risk or is a risk to themselves or other people. If they think they're going on to harm other people immediately, they would arrest them. But that is a tactical and strategic decision that officers will make, and she won't have any control over that. She can say, I'm really afraid, I want him arrested, but once she makes her report, the investigation is going to proceed with or without her. So we want to make sure that she knows that and is comfortable with that and trusts law enforcement to do that on her behalf. So there's sometimes when the officer wants to interview the suspect through the victim, and it's called the pretext phone call. And that is absolutely up to the victim whether they choose to participate and cooperate in that or not. Some of the reasons to do that is to try to get the perpetrator to say something to the victim on the phone that can then be used against them. So they might confess, they might say, yeah, I'm really, really sorry, I don't know what got over me. They're more likely to talk to the victim about what happened because the victim knows and was there. They don't think they're being listened to or recorded. They don't think the victim's going to report, especially if she's contacting him. And so they sometimes say very interesting things, which can be helpful to the prosecution. It also helps the detective to assess credibility, both of the perpetrator and of the victim, if she's saying something different to the perpetrator than she's reported occurred. It also can be very telling about what the perpetrator thinks of the victim or how they treat the victim. It locks in the perpetrator's story before law enforcement even talks to them or that they know that there's an investigation going on. And it can be used later at a trial or by the prosecutor to demonstrate what the perpetrator was saying initially before the formal investigation became known to him. So pretext calls are legal in Minnesota. Only one party has to consent to the recording of the phone call, and that would be the victim. And they sometimes work. They can make great cases, and they can enhance the second conventional interview, which is where the investigator is then talking with the perpetrator. They try to do this with the perpetrator not in custody. If the perpetrator's in custody, they have to read them their Miranda warnings and tell them they don't have to talk and that they're free to go at any time. They can have a lawyer. But if they're not in custody, they don't have to tell them all of that. They can just be hanging out, chatting with them. And this is preferably before the suspect knows of an investigation. They also can arrest them and then interview them later at the jail. They're not likely to talk at that point. So they'll use everything that was obtained in the pretext phone call, everything that the perpetrator said in that, and everything that the victim has told them to ask them. It's not uncommon for officers to downplay the seriousness of the offense or to seem sympathetic to the perpetrator to try to get them to talk. Oh yeah, when I was your age, yeah, girls in high school aren't that much younger than you are. That 14-year-old, I've seen a picture of her on Facebook. She's really pretty. And it sounds really gross if you're in the room with the officer doing it, but they're very strategic in how they say and do things to try to get perpetrators to let down their guard and to feel comfortable talking to them. It also allows them to talk about sex and what their beliefs about their right to sex, or that's what is and isn't rape, or what is and isn't okay. And they can make admissions doing this without even knowing that they're actually hurting themselves or making.
Amy, I do have a couple of questions when you're done with what you're going to say. Sorry.
Okay. I have 2 more slides and then let's do questions.
Okay.
Okay, thanks, Ty. So the final report is the one that's completed at the end of the interview with both the perpetrator and the victim. They may have gathered other evidence and talked to other witnesses. Law enforcement files a formal report and sends it to the county attorney or the city attorney, and they make recommendations of what charges they think should be brought and whether charging is appropriate. So as long as it's in an active status where law enforcement and the prosecutor are still looking at it and determining whether charges will be brought, it's not public information. The prosecutor can either say, yes, I'm going to charge, no, I'm not going to charge, or send it back to the investigator to do further work on the case. So like I was saying before, it's really important that we have those established relationships with law enforcement before you ever have a case. Be talking with them today before a client ever comes into your office, and describe your role and what you can do to help them and what they can do to help victims. And if you are hearing negative feedback about police, if you have a relationship with that officer, it gives you a really good opportunity to talk with them about how maybe next time things can look differently. And it's also important to give them positive feedback when they do a good job with a victim. Advocacy's role can be really important too in helping law enforcement keep the victim informed on the status of the case, because they don't always have the staff or think about doing that, and the victim really wants updates often and wants to know where things are at. So I am happy to take questions now, Ty.
Okay. So the first question was, so the person that asked the question has attended interviews where after the investigator officer is finished with their questions, they will turn around and ask the advocate, is there anything I missed? Anything you want me to address? In a situation like this, especially when there is something that should have been asked but wasn't, can I, as the advocate, speak up, or should I ask the officer to step out of the room with me, explain the question, and then go back in and have the officer continue with the question?
I think it depends on what was missed or what the question is. If it's something simple like just prompting her to tell another piece that she missed that she's told you before, or if it's something that's pretty critical that the officer just completely forgot to touch on, either asking to pause the recording for a second or stepping out can be a good idea too. So that depends on your relationship with the officer and if you feel comfortable saying, can you just pause that for a second? Or even just gesturing at it or something so that isn't on the recording. Or yeah, I think it really depends. I'm sorry, I'm not giving a very direct answer to that, but I can see it working either way. And
Okay.
it is appropriate to step up and say something if they gave you that opportunity. Absolutely.
Okay. Um, if you need more clarification about that, contact us, call us. But the next question is, so would you just suggest this for a victim, if it's safe, of course? And I had asked for more clarification of that question, and what what she's referencing is the pretext call. They've never heard of it formally called this. Is it only formally called this when the police are there with the victim listening? So would this be good counsel to give to a victim to make this call?
Not on their own and not without the police directing them to do it or helping them do it. Sometimes victims will do it. They'll feel that they don't have enough evidence and they want to trap him and get him to say something and record the conversation on their cell phone or whatever. And if they do that, presenting that to law enforcement is fine, but I would never encourage them to do that on their own. It can create it can actually create evidence that could help the perpetrator later if it's not done properly.
Mm-hmm. And I've actually done that before too with, law enforcement has asked me to talk to the person I was assisting to do something like that before too. And so as long as it's facilitated with the law enforcement officer and things like that, I think um, it helps the client feel more comfortable in doing that.
Yeah.
Hmm. Yeah, but I think doing it on their own, maybe suggesting to the client not to do that on their own. I don't know. How has the outcome been when you've done that? I'm asking the person. So if you just want to message what your outcome has been when your client does go off and do that on their own, has it been a positive outcome or what were some unexpected consequences came out from that? Okay. So then the next question, so if you say something, can you be subpoenaed? And this is going back to that question about if the officer didn't address a question and the advocate asked the officer to ask something, or would the advocate be subpoenaed?
I honestly don't know the answer to that. I would say no, but it's always a possibility. Defense attorneys can subpoena people. This might be a really good question to have our executive director, who's the expert on subpoenas, get back to you offline. So,
Okay.
Ty, if you want to document that and have Raina respond, that would be great.
Hmm. And if you want to message me your email, I will have Raina respond to that. Thank you. All right,
Are there
that
any more
is
questions at this time?
let me see. There's another one. Also, the discussion about the pretext calls. So what they have shown text or played the phone call for the police, and it was pretty much dismissed and not used at all, which was really frustrating for the victim. That was
Yeah.
a comment of what has happened, I guess. I asked her to
Yeah.
message like what has happened when that's done when it's not being facilitated by police, and that does seem likely that that would happen. I mean, in the cases that I've seen and I've assisted with, police were lacking evidence and was like, do you think you could get him to confess to doing it? Or so, and then they facilitated that phone call.
Right.
Okay. All right. That's what we had so far, Amy. Thanks.
Okay, thanks, Ty. Okay, so we've talked through the statutes and what constitutes the act of a rape, and we've talked through the law enforcement part. So now we're on to the prosecution part, where law enforcement has handed off their investigation to the county attorney's office. So what's important to remember in working with prosecutors, again, is developing that relationship ahead of time, and recognizing and helping to identify for the victim that the prosecutor is not the victim's attorney. The prosecutor is the good guy and who we want to work with to help us, but it's kind of gross to talk about it like this, but what really is happening is the prosecutor is representing the state and the bad guy is the defendant. So the prosecutor is saying, you broke my rules. My state statute says you can't do this. I'm going to prosecute you for breaking the rules. And that's what they're charged with, is breaking a Minnesota crime. The victim is a witness to that crime. The victim is going to be the prosecutor's main witness to present the case and to tell their story before a jury. And oftentimes people even refer to the victim's body as the crime scene. That's where the evidence is taken from if there's a SARS or SANE exam. That's where the bruises are and the marks are, and where the contact or penetration occurred. And so the victim really loses a lot of herself in that, and being aware of that ahead of time can be very helpful to them, because if they feel that the prosecutor is their attorney and working on their best interest versus working on behalf of the state and the best interest of public safety and the community, they can be very upset if they learn that later. It's really also important to remember that victims have a right to an attorney, but they don't always need one. If they have an advocate working with them or somebody who's able to be there and walk through the process with them and help them, having an attorney isn't necessary. But I have represented victims through criminal processes where it's been pretty imperative that they have had an attorney. So knowing that they have the right to have one can be important. And that attorney can be involved in the reporting and talking with law enforcement and present for those interviews too. But there aren't a lot of attorneys who practice in that area. So the prosecutor's job is to review the police report and the evidence provided to them by the investigator, and to determine whether the elements of the offense have been met and whether they believe that they can prove this beyond a reasonable doubt to a jury. And so if they can prove 4 out of the 5 required elements, but they can't prove one, they're required not to charge that. And a jury must find the defendant not guilty. So they have an obligation to resources also to make sure that they're not bringing cases that they can't prove. So again, there's a strategy in prosecution determining whether they're going to bring a case. Do I charge it really, really high, even though I know I can't prove that? And then, or I don't know if I can prove that, if a jury will believe this, and then I reduce the charges at a plea bargaining hearing? Or do I not prosecute it at all? Or do I prosecute the lower offense to begin with? There's a lot of thought that goes through that. So the charging document is typically called a complaint, and the prosecutor or the city or county attorney makes that decision whether or not they're going to file charges. There might be multiple counts charged for one incident, and the complaint will include the statutory language of what the maximum penalty can be for that charge. If a jury finds this person guilty of this charge, the maximum penalty allowed by law is 30 years in prison and a $40,000 fine. Although that's mentioned in the complaint, that is not the likely sentence, and that can be also very discouraging to victims when they find out later what the actual sentence will be. So being aware of that when you're reading that and helping them understand that if you receive a copy of a complaint is very important. The complaint must show that the perpetrator committed the offense, and the standard that the prosecutor has to be able to prove in a complaint is probable cause. Does the officer have probable cause to believe that this occurred? And does the prosecutor have probable cause to believe it occurred to file charges? But really what a judge is going to be looking at when they review complaints is whether it's beyond a reasonable doubt. So if a prosecutor's declining charges, if it becomes a habit, again, developing that relationship and talking with them and talking them through it, what do victims need to do to help make their crimes prosecutable, although that should never ever be the victim's job or the advocate's job. Oftentimes having that relationship can help educate other people about what best practices or about how to move forward with that. But if they do decline charges for a particular case, talking with them and asking, will you meet with the victim before you decide not to charge it? Will you talk to her and see if actually meeting with her changes your mind, or you understand something better that wasn't accurately reported in the police report? Or if you're not going to charge it, will you at least talk with her and explain why to her? Give her that respect and a one-on-one opportunity to ask her questions. Or will you consider lesser charges? If you don't think you can prove the first degree, will you charge the third degree? And they might not like that, but the more relationship you develop with them, the more possible it can be that we can encourage them. So the timeline after something is charged can take many, many months or a year or more to get from the time that it's charged to a trial. And continuances are very common and they're to be expected. Oftentimes a trial will be scheduled, the prosecutor will call the victim in, talk to them about the trial, prepare them to testify, and then it's canceled at the last minute and reset to 3 months later. And now she has 3 more months of anguish and trauma, being scared about this, and now what's going to happen, and why did it get continued, and what did he do? What is he tricking them into to make this happen? And understanding that just the system gets locked down and it has nothing to do with that can be helpful. If there are multiple continuances and it's really starting to affect the victim, you might want to speak with the prosecutor and say, she can't take this anymore. Can you try to make sure this case gets priority? But again, they don't always have control over that. The court administrator and the judges control their calendars pretty tightly. So there's 3 ways that charging can be done. The officer can arrest based on their probable cause and then submit their report to the prosecution, and then the prosecutor will decide whether to file charges or not. That's again creates that very quick timeline, which can make it difficult to have a very thorough investigation and report. The prosecutor can file a summons and complaint, which the complaint is mailed usually to the defendant with a date to appear for their first hearing. Or they can do a warrant if they don't believe the perpetrator will appear, or they believe after reviewing it that this is a significant offense that we want to get this guy off the streets quickly, then they can issue a warrant. So those are the 3 ways that charging can be done. Going through then the pretrial court proceedings, there's a lot of different hearings, and we only have 20 minutes left, so I'm gonna try to fly through this because they're pretty detailed. But the Minnesota Rules of Criminal Procedure govern what appearances the defendant will make and the timing of those appearances. So as the criminal process moves along, it's very common to have some hearings or even the trial continued more than once, and they're a normal part of the process, those continuances. and they can happen for a variety of reasons, usually scheduling issues for the judge, the prosecutor, the defense attorney, or if witnesses aren't available or they can't find the witnesses to get them to come to court, it can cause delays. There are 2 initial hearings, and in some communities they're held separately, and in other communities they're held together, and they're called the Rule 5 and the Rule 8 hearings, or sometimes they're referred to as the arraignment. So the first time the defendant goes to court, the main purpose is to advise the defendant what crimes he's accused of committing, assess whether they need an interpreter or any other communication assistance. The defendant receives a formal copy of the complaint and any documents attached to the complaint if they've not already received it. They can ask that it be read on the record, but typically that's waived. The prosecutor can request that the court order the defendant to be booked, which means that he's going to be fingerprinted, photographed, and if they are charged with a felony or gross misdemeanor, they don't have to plead guilty or not guilty at the Rule 5 hearing. That would take place at the Rule 8 hearing. If they're charged with a misdemeanor, they typically do. The court also informs the defendant that he has a number of rights, including the right to remain silent, the right to an attorney, and the right to trial, and also assesses the defendant's financial circumstances to determine whether it's appropriate to appoint a public defender for them. If the defendant is in jail or in custody at the time of the Rule 5, the prosecutor usually requests that bail be set with conditions of release. Bail or bond is an amount of money the defendant has to post with the court to be released, and that money can be forfeited or kept by the court if the defendant fails to show up for future court appearances. In Minnesota, every criminal defendant has a right to bail before his or her guilt is decided at a trial. Conditions of release may be set even if the defendant is not in custody, and may include things like no contact with the victim, no leaving the state, no use of drugs or alcohol. They may be put on electronic home monitoring or other conditions to ensure community safety. And if they violate any of those conditions, they can be brought back to court to consider whether bail should be set or increased as a result of the defendant's actions. The defendants cannot be held without bail ever before the trial, even for violations of the conditions of release. They still get the opportunity to post bail. So that second appearance, or the Rule 8, which can be held at the same time as the Rule 5, depending on the community, is the time that the defendant has either hired a private attorney or is now with the public defender. And that's where they decide to wait. They have an opportunity to waive that Rule 8 hearing and just do all of it together at the Rule 5. This is where they plead guilty or not guilty to the complaint, which is referred to as their plea. Most defendants plead not guilty at this point, and their attorney will decide whether or not they want to ask for an omnibus hearing. So an omnibus hearing is an evidentiary hearing, but it only takes place if the defendant has pled not guilty and the defense attorney has specifically requested it. It's held within the first 28 days after the first hearing, and the defense attorney has to specifically notify the prosecutor what they're challenging. This is usually a constitutional challenge where they're saying the police did their job wrong. They have this evidence against my guy, but they got it illegally. They violated his rights when they got it, and so you can't use any of it. Or they say there's not enough evidence here to even charge him with the crime. So the court makes the decision about the requests of the defense attorney and the prosecutor. Both present arguments. Oftentimes law enforcement's called as a witness at this time. It's very, very rare that the victim would be required to testify at this point, because this is really about the constitutional rights of the defendant. So the court decides whether the specific pieces of evidence are admissible and whether there's enough to show probable cause to believe that the defendant is guilty. And if they decide that the law enforcement officer did violate the defendant's constitutional rights, they decide whether that piece of evidence will be excluded from any trial, which then makes it possible for the case to be dismissed, because then there's no longer probable cause. Without this piece of evidence, we no longer have probable cause. So this is a really nerdy, brainy lawyer kind of a hearing, and has very little specific impact on the victim. She has a right to attend if she wants to, but she's not required to. Usually the police reports and any taped transcripts are submitted to the court at this point as well. So the next hearing is the plea hearing, and this is often called plea bargaining. So a defendant is convicted of an offense if the court accepts and records any of the following: the defendant's guilty plea, a guilty verdict after a jury trial, or the court finds that they're guilty after a court or bench trial, which is held before the judge alone without a jury. So defendants can waive the right to a jury and decide to just have a judge hear it. Plea negotiations can lead to an agreement between the defendant and the prosecutor about how the case should be resolved. About 98% of criminal cases result in a guilty plea of some type after plea negotiations, but this might be a significantly reduced charge. While some people think of this negotiation process as somehow allowing the defendant to get away with it, the truth is that it can result in just as tough a conviction or sentence as if the defendant went to trial. Two decisions are usually discussed in plea negotiations: which offense the defendant will plead guilty to and what sentence will be imposed. The prosecutor may require a defendant to plead guilty to one of the charges already charged, or may agree that they can plead to a completely separate offense that wasn't initially charged. Normally, they agree to recommend a certain sentence to the court, and the defendant is free to argue to the court for a lesser sentence. Sometimes, though, the two sides reach an agreement about what the sentence they think should be imposed, and the court is basically expected to follow that sentencing agreement. The plea negotiation generally involves some give and take between the prosecutor and the defendant. The prosecutor gives up the opportunity to take the case to trial, in which case the prosecutor might be able to obtain a guilty conviction to the most serious charges and have the most severe sentence possible imposed. In exchange for giving that up, the prosecutor gains the certainty of a conviction, even if the conviction is for a charge that's less serious than the one in the complaint. The prosecutor also gains the opportunity to shape the defendant's punishment and obligations and help to develop a correctional plan that will address the defendant's individual situation. The likelihood that they'll reoffend will hopefully be decreased by this. Similarly, the defendant is giving up rights. He's giving up the opportunity that he could be completely acquitted at trial. However, the defendant avoids the risk that he or she will be found guilty at the trial of the most serious charges and have to have the most maximum penalties. So when a defendant decides to plead guilty to an offense, the court holds the plea hearing and they sign and review a Rule 15 petition with the attorney. And this is a written document that the defendant signs saying that they have been fully advised of their rights, they're waiving any rights to a trial. They're reviewed on the record so that the judge is sure that the person understands what they're doing before a plea is entered, and that they're clear-minded and fully understand what they're doing. So the purpose of that is that they can't later withdraw their guilty plea and say they didn't understand, because their rights are all reviewed at that time. Once the defendant's fully advised of their rights, they'll give a factual basis for the offense. That means that they admit to committing the elements of the offense to which they're pleading guilty. The record must be clear to show that the defendant actually did the crime that they're pleading guilty to, even if it's only a really minimal admission to the most basic acts necessary to violate the statute. So sometimes the defendant will just tell their whole story and admit to everything, and other times the public defender will walk through the elements of the offense with them, and they say yes or no, which can be very unsatisfying to a victim. There's also a kind of plea called an Alford plea, where the defendant basically just says, I know if I went to a jury trial that you'd find me guilty, so I'm just going to take this offer the state made. But I'm not going to say I did anything. I'm not going to admit to anything. I don't acknowledge that I committed any offense, just that if we went to trial, they'd find me guilty. The legal standpoint of an Alford plea is exactly the same in all other ways as a regular plea. Sentencing and supervision are the same. The only difference is that the defendant has not said that he did it. And in sexual assault cases, these are usually disfavored. Sexual assault perpetrators need to take responsibility for their offense, or treatment isn't possible and they won't be rehabilitated or ever able to re-enter the community. So if they won't acknowledge it, the judge is usually more likely to require them to go to trial and have the maximum sentence imposed. The prosecutors also are going to consider the victim at this point. They talk with the victim about what they're thinking about doing it, what they're thinking about offering, what the possible consequences are, and why they think that's the best thing to do. They may be wanting to save the victim from having to testify, or they may determine after meeting with her that she's not a credible witness, or that they don't think the jury will believe her, or that she's too traumatized to be able to testify, which is often a very paternalistic point of view. And as advocates, it doesn't feel very empowering or autonomous on behalf of the victim, but it is one thing that prosecutors will consider in offering a plea. So if there is no guilty plea, then the pretrial will occur, and this is a very boring procedural kind of a hearing again. It's basically for the judges and attorneys. Sometimes they don't even go into the courtroom or go on the record. They often go in chambers to talk about it, and they'll discuss the legal issues. They'll discuss any pretrial motions. Either the prosecutor or the defense attorney can write motions to the court asking for certain things to be allowed or for the jury to be told certain things. They'll talk about timing. How long is the trial going to take? How many witnesses do you have? How many witnesses do I have? Can we stipulate to anything that we just say the jury can have this information and we're not going to fight about it? So that's usually a very short hearing that the victim also does not need to attend, but they have the right to attend all the hearings that they want to.
Amy, I
Yeah,
have a couple of questions about pleas. Do you
okay,
want me to ask them now, or should I wait till
sure.
the end? Okay, so the first one was going back to the Alford plea that you were talking about. Um,
Mhm.
they're just asking, what is the point of an Alford plea, and how would this benefit either party?
The point of it is to get a conviction for something if the prosecutor is not sure that the jury's going to convict, but the defendant is scared that the jury's going to convict, and so they'd rather reach agreement to have a lesser sentence. I'm pleading guilty. I'm not making you go through the process of a trial. I'm not making the victim testify. I am going to accept this lesser charge so that I can have a lesser sentence. So that's the benefit to the defendant. The benefit to the prosecutor is they still get the plea, the person's still guilty, and they still get to have them sentenced without having to put the victim on the stand, without having to go through a trial, and without the risk that a jury could find them not guilty. But
Okay.
the biggest benefit to the defendant is they don't have to say they did it.
Okay, that makes sense. There's another question. There is another plea, and can't think of what it's called, but it's when they can't remember because of mental illness or chemical use. Do you know what kind of plea that is?
There are defenses available that they can claim they're not competent or they're not they weren't responsible at the time. They're called Rule 20 investigations typically. The defense attorney can make a defense saying either my client is not with it enough, they're mentally ill or high or
Is it
whatever that
called the Norgard plea? Somebody just messaged that. Do you know of that?
um, I have heard of it.
Mm-hmm.
I think it's usually after a Rule 20 is not successful that they basically say, yeah, there's enough evidence here to say I did it, but I was too drunk. I don't remember.
Okay.
But I must have did it. There's evidence. I see that I did it, but um, I'm not as familiar with that. I'm sorry I didn't include it in here.
Mm-hmm. I guess going back to one of the other questions from before, I did pull our ED aside and asked her the question, and this is the question about if you do say something on the record as an advocate, could you get subpoenaed? And I brought that question to Raina, and her response was, yes, you could get subpoenaed. The best method to go about doing something like that when a police officer says, is there something I missed? Is there something else I should bring up? Um, Ask to speak with your client outside of the room and then pull your client aside before you bring up anything in front of the officer. Because number one, you want to make sure that whatever it is the officer forgot to bring up, that the victim is comfortable in bringing that up and is wanting to talk about that before you even, let law enforcement know about it. And also, it's just then you're not in recording, you're not under the record for any reason. So the best way is just to say, can you excuse us for a second? I'm gonna just take a couple moments to speak with the victim here. So Raina said that that is the best method because you might get subpoenaed. You never know.
Thank you for asking her.
All right, that's all we have of the questions so far.
Okay, so um, I'm going to try to get through the trial as quickly as we can. We're not going to get through the whole slide presentation that I've provided to you. We only have about 3 minutes left here, so Ty will probably be doing a second webinar, like
Yeah, would follow up with this and talking more extensively than about the criminal court process after the report has been done and it's going to go to trial. We can do something like that, Amy.
okay. Would you like me
Okay.
to go through the trial now, or?
Um, let's save that since we do only have a couple minutes left. If you wanna, yeah.
Okay, so we'll note that we stopped right at the beginning of the trial. We'll have part
Mhm.
2, and we'll let you know when that's going to be. We'll try to get it on the calendar maybe sooner than we regularly would. And thank you for your questions and your participation. I'm just going to flip down to the end of the screen here. So I put my phone number and my email, that's my direct number, at the bottom. So if there's specific criminal questions you have as you're working with a sexual assault victim going through this process, obviously we've talked for an hour and a half and we haven't even gotten to the trial yet. So it's quite extensive and quite detailed. It is quite different than domestic abuse. We really appreciate all you advocates and all you do for victims and survivors of domestic and sexual assault and violence. And we are here anytime. Call us. You are never, ever, ever bothering us. That's what we're here for. That's why we exist, to help and support you guys and to answer any questions you have. So thank you for attending today, and we'll wrap this up and we'll schedule part 2, and Ty will get that information out to all of you in the next week or 2.
All right. Well, thank you everybody for sitting in and staying with us for the full hour and a half. Like Amy said, we are ending now since we want to be mindful of your time, and we do have 90 minutes blocked out for each webinar. So be on the lookout for more information on part 2 of this. Thank you.